You're getting remarried and congratulations, but before you say I do, there's something critical that we need to talk about first. I'm Ryan Williams, a partner at Allied Legal, and today I'm going to explain a little bit about why estate planning for second marriages is completely different and what happens if you get it wrong. So here's the uncomfortable truth. In Iowa, if you pass away without an updated estate plan, your new spouse could get a portion of your estate that you do not intend for them to receive. And your children from the first marriage, they could get the other part. That might work for some families, but for most, it creates some serious complications. Now, here's what really catches people off guard. If you die and you leave everything to your new spouse, there's absolutely nothing stopping them from later changing their will and cutting your children out completely. In fact, that happens very often. Your stepchildren could end up with everything you built, while your own kids get nothing. First, many Iowans remarry and they never update their old estate plan. That old will might still name your ex-spouse as a beneficiary, and they could be named on life insurance policies or retirement accounts. And yes, even after divorce, if you have not updated those beneficiary designations, your ex could very well inherit instead of your new family. Second, many Iowa couples assume that a simple will is going to be enough. And it's just not. Traditional estate planning that leaves everything to your surviving spouse can be absolutely devastating, especially for blended families. Your biological children could face the very real possibility of being completely disinherited. Now here's another layer. Under Iowa law, stepchildren are not automatically going to be recognized the same way that biological children. Even if you've raised your stepchildren as your own and you want them to be provided for, you need some explicit planning. Without it, they could receive nothing. This is where trusts become essential. A Q-tip trust, which stands for Qualified Terminal Interest Property, lets you provide income for your spouse during their lifetime while making sure that the principal goes to your children after your spouse passes away. You take care of both your spouse and your kids. Life insurance can be another wonderful solution where you can leave certain assets to your spouse and use life insurance to ensure that your biological children receive their inheritance regardless of what happens down the road. Now look, I know that this is not the most romantic topic in the world, but here's the reality. Up to 40% of households with children in America have blended families. And without proper planning, I have seen families torn apart in probate court. Siblings fighting with step-siblings, children feeling betrayed, and the key to all of this is open communication. If we sit down with your new spouse before the wedding, talk about your goals, what do you want for your kids? What do they want for theirs? What do you want for each other? Estate planning for blended families is complicated. There's no way around it, but that's exactly why Allied Legal works to help blended families come up with a plan that works for them. We help Iowa families navigate these sensitive situations every single day. We will sit down with you and your new spouse, and we will help you understand your unique family dynamics. And we'll work with you to create a plan that protects everyone you love, your new spouse, your biological children, and your new stepchildren. So if you're interested in learning more about how to plan for blended families, please give us a call, schedule your free strategic planning session with Allied Legal. Let us help you design a plan that keeps your family together instead of tearing it apart. Click the link down below to get started.